The Trump administration delivers, finally, on some long-promised changes to the H-1B program. Are we really going to tighten up and protect American workers? Here to tell us more about it is Preston Huennekens, who is our Government Relations Associate with FAIR's Government Relations Program. Of course, I'm Dan Stein, and if you're watching this on YouTube, you want to hit that subscribe button. Get to see all of our latest content. Don't want to miss that because some of the stuff is really late breaking. So, Preston, a lot of concern about the H-1B program for many, many years, labor displacement, Americans getting fired and having to train their replacements. And then the H-1B, the so-called foreign labor program, has been used in all variety of fields to depress American wages, make it more difficult for young people coming out of school to actually get jobs in even some of these tech companies. Give us in a nutshell, what did the Trump administration just do and why is it so important?
Right. And the H-1B program, like you said, is a program that almost everyone agrees has issues on both sides of the debate. And so what the Trump administration has done is they're proposing new rules that are going to go into place very rapidly. And they're, for the justification of this, they're citing the economic effects of the coronavirus, which has affected millions of people. We're still at about 8% unemployment nationwide, which is double the pre-COVID rate back in February and March. So what these two rules are doing, and they came from two different agencies. The first is from the Department of Homeland Security. Mm-hmm. Their rule specifically deals with enforcing worksite visits, putting a little bit more teeth behind that enforcement mechanism, allowing DHS to go into more work sites and make sure that H-1B workers are actually doing what they're certified to be doing, making sure that these companies have not displaced Americans when they hired H-1Bs in the first place. Mm-hmm. And additionally, with the DHS rule, they put into place, just generally a more overview of what a specialty worker, what that definition means. And that's something that has really been used by some unscrupulous employers to pay, really not specialty workers very below average wages. And it allows them to operate, a very kind of shady business model where they hire and certify a large number of H-1Bs, bring them over to the United States in these specialty roles, which aren't really specialty, and then displace American workers.
Yeah, so that's the original concept of H-1B was temporary, short-term, emergent, unforeseeable workers who could be used until American workers could be trained in these fields. And it had its genesis in the late 1980s with the personal computer boom and early stages of the tech boom, but long before the internet. 1990 is when H-1B was created, long before the internet. And the idea was a limited basis for very specialty, high-skilled kind of workers. The specialty occupation category has now been blurred to kind of mean any kind of degree related to a job, which is complete dilution over time. Every aspect of the H-1B program has come under attack, widening, broadening, as you say, unscrupulous employers, immigration lawyers, and others have found innovative ways to shoehorn in now contract workers. None of this stuff was ever envisioned in the way that the H-1B program was originally drafted by Congress.
Exactly. And that's the biggest thing. And especially with the specialty occupation, there was really no set definition for it. That's not really, the way it was written originally was so broad that, like you said, all of these parties were able to interpret it and successfully, certify some of these workers to come over and undercut Americans because there was no set definition. And that's what DHS is trying to do with this rule. And we think that they're going to be pretty successful in doing it. And then obviously there's another rule entirely that has to do with wages that came out of the Department of Labor. And without getting too into
we have a set of DHS regulations, so you cover that. Now you're moving to the Department of Labor, and they're looking at wage rates, okay? So what do these new rules do?
Right. So without getting too into the weeds, this pretty much raises the cost of hiring an H-1B for an American employer. And that's very important because that is really the key issue at stake with any kind of guest worker program, and particularly H-1Bs, is that if you are able to hire them at wages lower than an American for the same job, the company is almost always going to hire that H-1B. So what this rule from DOL is doing is raising those wage rates for H-1Bs when they're certified so that it's more on the playing field, and in some cases will be more expensive to hire an H-1B than it would be to hire an American worker.
Well, sometimes when we see these lists of average salaries for H-1B workers, they really are talking about what the employer is paying, but they don't count things like labor contractor fees and other middlemen. So in many cases, these salaries are really inflated, but they're actually paying the worker. And there's so many reasons why an American worker is put in an unfair disadvantage, even if an American worker is better, because of the desire of an H-1B worker to get a green card eventually and believing they're tethered to that employee, the idea that they're going to be bringing in relatives who are all counting them back in the home country, these days usually India or China, to petition relatives. So an employer says, wow, what a great malleable employee who's willing to work all weekend, sleep on the floor, whatever, to make me happy, versus what an American wants, decent wages, decent standard of living, opportunity for growth and advancement. And gee, wow, I mean, this program is great. So, yeah, why wouldn't they lobby Congress? So I assume there's opposition to this, what is really obviously a long overdue idea.
Of course, there's going to be opposition from immigration lawyers, from some of these groups that have completely, really tethered themselves to bringing in H-1B workers as a business model. And even some of the larger tech companies are going to be really upset with this because they've relied on these workers for so long. And it's, because again, like you said, these workers are essentially tied to this one employer. An American, if they find a better offer, can leave a company and go take another offer. An H-1B worker can't do that as easily. An H-1B worker can't really negotiate for a higher salary because that would affect the way that the certification process works. An American can argue for a higher salary based on their performance. And so you're going to see a lot of these larger tech companies that have relied on these workers for so long as such an important part of their workforce getting really upset that they're going to have to start paying them pretty much the same wage as an American in the same job, even though they probably know at the end of the day that's the right thing to do.
Mm-hmm. So it's funny because, I'm happy to say that FAIR has just produced a report released a couple of days ago, which is a blueprint for putting the American worker back to work. And it represents the fine work of our government relations program that put this thing together. But we basically went back and took a look at various employment patterns, the E-Verify program, as well as the non-immigrant visa categories we're talking about here, H-1B, L, and OPT and others, and puts together a series of recommendations, which if the Trump administration were to follow it, and of course this week they do seem to be following some of it on H-1B, would really help ensure that when the economy recovers, it is American workers who really are getting a shot at these jobs. So the actual name of the report is A Blueprint for Putting the American Worker Back to Work. It's available on our website. Precise title is close to that anyway. And you can download it, and it's an easy read. It's only about 15 pages long. But Preston, give us a couple quick highlights on what you think the key takeaways are from that report.
Yeah, absolutely. There's really three main points that we tried to hit on when drafting this report. First is explaining the importance of E-Verify and mandatory nationwide E-Verify for all employers, for private employers, government employees. Anyone that is hired in the United States has to go through this program. This would deter illegal immigration more than any other enforcement program or policy change we can think of. Second is that we have to reduce legal immigration to a sensible level and transition to a merit-based program. This is something that President Trump had floated in 2017 and 2018, but never really made a push to get done. It kind of sizzled in Congress and nothing was ever really done with it. But that is so important to transition from what we have now, which prioritizes your family connections throughout the immigration process. We want it to prioritize your skills and what you can bring to the American economy. And then third, we need to completely overhaul and in some cases end guest worker programs like the H-1B like OPT, like the H-2B, that depress wages and that rob American workers of job opportunities. So those are really the three key points that we fleshed out in this report, and that we think would really be a successful blueprint for the American worker and for the American economy.
Now, the genesis of these ideas is not new. Employer sanctions were passed in 1986 after a decades-fought battle, going all the way back to 1948 when Peter Odino, as a first-term member of Congress from New Jersey, introduced them, trying to close the so-called Texas proviso that said mere employment was not harboring under felony harboring statutory criminal provisions. And here we are all these years later. 1986 law that Ronald Reagan signed gave amnesty to a lot more people than they projected were going to get it. But in exchange for that was a solemn commitment that they were going to get illegal immigration under control. And a big part of that were employer sanctions. That if you hired illegal workers, you were going to be penalized, and there was going to be a document structure built in to ensure work eligibility. The E-Verify program, here we are like 30 years later, and we are still battling to try to get E-Verify used routinely by all employers in this country, which is a critical step in controlling our borders. The amnesty program in 1986 was real, but the employer sanctions turned out ultimately to be fake, as Chris Caldwell says in his new book, Age of Entitlement. And for those of us who remember that part of that compromise, you would think we would have learned something from all that failure. After all this time, we would still be fighting this battle. It's hard to believe. E-Verify is simply the only thing that makes sense as a first stage process of controlling illegal immigration. And naturally, a lot of the stuff going on now with voter fraud and voter fraud concerns might not be such a big issue if we had established a process of verifying identity and work eligibility and citizenship decades ago, as was recommended, and now most recently by the 9/11 Commission in the mid-2000s. So here we are today facing the situation where the non-immigrant visa programs, which also got most of their start or expansion in 1990, are finally being addressed by an administration that may or may not be here in another month, 2 months, 3 months. Credit the Trump administration with doing this now when it finally got done, because it would have been nice to have it done earlier, but they have to overcome enormous corporate lobbying odds, a lot of Wall Street money going in to help the Biden administration, election campaign right now, which tells you a lot of where they stand on some of these issues, but credit the Trump administration for taking on some of these big business lobbies. So we need to fight to make sure these regulations and new rules stay in place. They're likely to be challenged. They will be challenged, no question about it. Every single thing the Trump administration has tried to do to protect American workers, seal the borders, bring asylum under control, make sure that there's no labor displacement, has come under really aggressive assault from either the ACLU or from, in this case, it's going to be the Chamber of Commerce. These big users of these companies, Microsoft, Netflix, Facebook, Google, these companies ought to be providing fabulous opportunities for American workers in the United States. And instead, they have become addicted to this foreign labor stream and then wonder why the public is alienated, why young people are alienated. So resolving the non-immigrant visa program and problem is a big part of helping young millennials and others get a foothold in this economy, because the current trends are very troublesome otherwise. Anyway, concluding thoughts here, Preston?
Again, just hitting on what you said, these are big moves from the Trump administration, early in October. And although it's a little bit in the weeds with the federal rulemaking process, but these are two rules that are going to hopefully, put in some much needed reform to the H-1B program, and to read more about other reforms that the administration can take. I recommend that everyone read the Blueprint for the American Worker document that we have on our website.
Yep, Blueprint for the American Worker. You can get it off our homepage and find it with a quick search, but it's easy to find. I suggest you download the report, take a look at it today. There was fabulous work by our folks there. And again, I'm Dan Stein. Subscribe if you want to get our videos. And we'll be back with more great content, tell you what's going on the immigration policy front, as well as important fair victories as we move forward. Thanks for joining us.